And we've already stated that there was no single colonial experience. One's circumstances in the colonies depended very much upon where one lived. This was true both in terms of the colony, the law under which Virginians lived would be vastly different from that under which Massachusetts peoples lived, as well as region. Now, by region, we can actually think about much larger regional collections of colonies. For instance, the New England colonies of Massachusetts, Connecticut, Rhode Island. This formed a region which was much more congruous, and certainly the people there had much more connections than, say, with each other rather than they would have with people down in the Chesapeake colonies, Virginia and Maryland and Delaware. And likely the middle colonies, which could actually include Delaware, Pennsylvania, and New York, as well bred an entirely different system of law as well as a different culture. And don't forget, of course, that even south of the Chesapeake, when you get down into the Carolinas, particularly South Carolina and eventually Georgia, you simply don't, you see a very different style of colony developing there as well. And regardless of this, if you lived anywhere along the western Appalachian frontier in the 17th or 18th centuries, you were away from the established authority of the seaports. And so law and order out on the western frontier looks very different. So the variety has to be understood as the norm in colonial America. As we'll see, this actually works to our benefit when we're considering legal history because it raises the possibility that we need to interpret legal documents in order to be able to explain local variants. And this is something to which we will return. But for right now, I want to actually focus on some of the similar traditions and institutions and even experiences for the colonists. So for this short institutional lecture, I will try to be mindful of the common experiences and the local variations, but I will really focus on the common experiences. And we begin with the legal system that all colonists lived under. Every colonist lived in a system of layered justice. And this broadly reflects it here. There were three levels of courts. If we start at the top, the highest court was the Colonial Assembly. There was a layer underneath that of superior courts, and underneath that of local courts. Very much like in England, this area here with the local courts is where about 90% of your real legal experiences go on. Superior courts exercised a good amount of control, and we'll see historically that the Colonial Assembly, although it begins very important, ultimately does not have as big a role. But we should begin there as well. The legislature of each colony served as the highest court of the land. This followed the British custom in which Parliament was the highest court in England. Of course, by the 17th century in England, Parliament had shed most of its judicial functions. But in the early colonial experience, it was not uncommon to see the Colonial Assembly acting jointly as a legislature and as a court. In fact, the Massachusetts legislature was called the General Court, and it acted as such. Very early, these legislatures acted as courts of original jurisdiction. A key example of this, but by no means the only example, is the trial of Anne Hutchinson in Massachusetts in 1637. Eventually, however, legislatures shed this original jurisdiction and exercised only appellate jurisdiction. And eventually, of course, the legislatures would shed all of their judicial authority. Importantly, they did not do so during colonial America. During colonial America, the colonial assemblies still functioned as courts. Below the legislature were the superior courts. These courts had two kinds of jurisdiction. One was over felonies. This is their criminal jurisdiction. In this way, they were like the assize courts of England. They also entertained civil cases. These superior courts went by different names in the different colonies, but as each colony's legal system developed, they developed this layer of courts. These superior courts also had a limited appellate jurisdiction over local courts. Local courts, by the way, would also come in a variety of names. But I want to draw this distinction here with jurisdiction. Colonial courts, we can talk about jurisdiction in terms of its Latin roots, the right to speak the law. jurisdictio, speaking of the law. So a court has either a general or a limited jurisdiction, and jurisdiction can then be further divided. There's subject matter jurisdiction, that is, is a court a competent court of criminal or civil jurisdiction? There's jurisdiction over certain kinds of people. So some people may be allowed to bring matters in courts and other people not. A very simple example of this is two very simple examples, actually. One is slaves. Slaves were not allowed to bring cases before court. They had no legal personhood. And another category of person in colonial America that could not bring cases to court were married women. Married women had no right to bring a case before a court. A court had no right to take jurisdiction when a married woman brought a case before them. So that's jurisdiction over people. And the final, of course, is territory. If you are in Massachusetts negotiating a contract, you can't go to a Virginia court and try to litigate it there because that court has no authority over something that happens in Massachusetts. So I want you to understand here, when we talk about these superior courts, we're talking about the delineation of different kinds of jurisdiction. And then the final one, of course, is this question of the review of judicial proceedings, and that is appellate versus original jurisdiction. And the superior courts had both. They had both appellate and original jurisdiction. The final layer is the local courts. Now, local courts also come under a variety of names. In Massachusetts and New York, they were typically called quarter sessions courts. In Virginia and Maryland, these were county courts. The county courts, or these local courts, did not just hear petty crimes and civil cases. They also did a fair amount of administration. They cared for the poor. They heard petitions. They maintained the roads and the bridges, or at least ordered people to maintain roads and bridges. They assessed taxation levels. They collected taxes. They provided for ministerial officers. They issued marriage licenses. They licensed tavern keepers, millers, and ferry operators. In short, they were the central administrators of county government. These courts were staffed by justices of the peace. Typically, each of the county courts or local courts would be staffed by a quorum, which meant that at least 3 or 4 or 5 justices of the peace would be necessary in order for the county court to sit and hear cases and issue rulings. When not in session, the justices I'm going to call them JPs, Justices of the Peace, JP. When not in session, JPs had a kind of limited petty jurisdiction of their own over petty offenses and other small matters. But let's not get thrown by this kind of fancy pants rendering of appellate justices on superior courts and local justices of the peace. None of these people, despite their titles, had any legal training. As we will see, law schools don't really become established in America until about the middle of the 19th century. And in colonial America, there was no formal legal means of training any of these guys. Some of them knew the law from study in England or from practice, but most just read a few books on the subject. They were not experts. They were typically picked by the governor, and the governor in most colonies, certainly in the 18th century, was a royal appointment. Nonetheless, governors tended to pick from a list provided by the local assemblies, and given that the royal governor's salary was paid for by the colonial assembly, governors tended to take the advise and consent function of the local assemblies reasonably seriously. But the people they were appointing were not lawyers in any official sense of the term. And despite saying all of this, I want to make very clear that judges and courts were tremendously important. Court days were a point of gathering for the entire community. People on remote farms came into town for court day to pay their taxes, to protest assessments, or to take care of other business. This was especially important in the rural colonies of Virginia and Maryland, where there were few other days of communal gathering. Judges were, perhaps in many ways, secondary in importance in colonial America to juries. The jury was enshrined in many of the local charters themselves. It should be noted that the jury as an institution was not used in every instance. Of course, petty jurisdictions, such as the individual court of the JP, proceeded without juries, and they still do today. But so too did the very serious trials for sedition and heresy in early colonial America. In those cases, in which colonial assemblies tried the cases as a court of original jurisdiction, no independent jury was assembled. Nonetheless, juries became regular fixtures in the courts. The system of justice in each colony was different, but they all followed this general historical development. They began as one big court, what we think of today as a legislature, ultimately delegated original jurisdiction to lower courts, developed a process of appellate review of judicial decision-making, and ultimately formalized into a coherent system. There was, of course, the final review of the Privy Council of England over any judicial decision-making. But to make it clear here, only 3 cases a year between 1696 and 1775 were appealed. That's if we average it out. I'll repeat that because it's important. Only 3 cases a year between 1696 and 1775 were appealed to the Privy Council in England from any of the colonies. A common inheritance for all colonists in the 18th century, therefore, was this local system, and most importantly, the criminal and civil jury. Now, this, by the way, gets us to an important thing. I've talked here about common inheritances, and these two are very important. Trial by jury, the ubiquitous jury, whether in civil or criminal cases, appellate justice, also being a very important feature of this system. These are common inheritances. And I want to say right now, it is very tempting for us to start drawing lines between this and various provisions in the Constitution, but we have to be careful. And one of the ways to illustrate this is to think about some of the things that this legal tradition did not bequeath the founders. One very important one is any kind of concept of separation of powers. There was virtually no separation of powers during this time. Think about it. Legislatures acted as courts. Local justices acted as executive administrators. You have combinations of powers in virtually all of the offices. So they don't really have a very strong conception of separation of powers. And another is the question of judicial independence, or an independent judiciary of any kind. Judges were picked by governors in colonial America. They essentially served, by the way, at the governor's pleasure. This made them dependent upon the will of the governor, and as we'll see when we look at the Zenger trial I think it's in a week or two, this could really impinge upon the independence of judges. But it wasn't just governors who limited judicial independence. Assemblies in the 18th century exercised a lot of control over judges. They paid their salaries, and they could vote to end or reduce their salaries. They also impeached or threatened to impeach judges who overstepped their bounds. In several states in the 1760s and 70s, judges, who were oftentimes seen as shills for royal governors, found themselves besieged by colonial assemblies who believed themselves to be representing the people. So while we can observe the rise of a true judicial system, complete with courts of appellate jurisdiction and separate criminal and civil jurisdictions, colonial America did not produce an independent judiciary.